Hello, everybody. Welcome to another episode of the UPC Insights. Today, we're delving into an intriguing and somewhat unsettled topic in European patent litigation, the potential application of the file wrapper Estoppel doctrine at the Unified Patent Court. This doctrine, which has significant implications in jurisdictions like the U.S., could shape or reshape, I should say, how patent claims are interpreted if adopted by the UPC. To unpack this, we'll look at the recent UPC decisions, examine how the doctrine aligns or clashes with European principles, and discuss what this uncertainty means for patentees and litigants. Joining me, as always, is our expert, Tilman Pfrang. Tilman, so do you have your bathing suit on?
Yeah, absolutely.
Okay, so we're going to dive in deep today. So, first of all, overview of file wrapper Estoppel doctrine. Tilman, for our listeners who might not be familiar with this concept, could you briefly explain what the file wrapper Estoppel is and how it's typically applied in jurisdictions like the U.S.?
Yeah, I can do my best. I have to say I'm not a U.S. lawyer, so this is my understanding of U.S. law. It's not legal advice in a narrow sense.
Okay.
But as far as I understand it, how it's done in the United States and similar jurisdictions is, let's start with what actually estoppel means. Estoppel is a legal principle that prevents you from asserting something contrary to what you implied by your previous actions.
Okay.
If it would harm another party who reasonably relied on those previous actions. So this is a estoppel in general. File wrapper estoppel is something special of patent law. And this file wrapper estoppel we are talking about, also known as prosecution history estoppel, is kind of a doctrine that can limit the interpretation of patent claims based on the statements or amendments made during the prosecution process. Essentially, then it prevents patentees from arguing for a broader claim scope or broader interpretation during litigation than what was defined or conceded during the prosecution phase. Let's give you an example. If a patentee argues for a certain interpretation of the patent claims during prosecution to overcome a rejection based on prior art, this patentee might later be stopped from arguing that any broader scope or broader interpretation of the claim applies when determining infringement. The logic is to ensure kind of a fairness towards third parties who rely on the public record of the patent prosecution to understand the scope of the patent and avoid infringements. Now, as far as I understand, being not a US lawyer, in jurisdictions like the United States, such file wrapper estoppel is often a key consideration, particularly under the doctrine of equivalence. I would not say in all jurisdictions it's limited to equivalent patent infringement. It may also be applied to literal patent infringement, but as it appears in the United States, at least it's very much relevant when it comes to equivalent patent infringement. Yeah, well, that's maybe a short overview over the file wrapper estoppel.
Yeah, I mean, that's pretty interesting. I mean, my U.S. compatriots there, they seem to have it together. So how does this doctrine contrast with the European approach to claim interpretation under the EPC and UPC practice? Now, that's interesting to me.
Yeah. Now I'm a bit on a safer ground because I actually...
You know something about this one, huh?
Yeah, I actually legitimated to give advice for EPC and UPC issues, being an EPC and UPC representative. It does not play so much a role before the European Patent Office, so under the EPC as such, I would say. In the EPC, very importantly, we have the Article 69 EPC and the protocol, which says there is equivalent patent infringement and which says also how interpretation should be done. However, this does not play a huge role at the European Patent Office. It plays a very decisive role before the UPC, the Unified Patent Court. And in general, I would say the European practice is rather different to the US style. As said, in Europe, the framework is Article 69 of the EPC and its protocol, which govern claim interpretation. And the focus here is clearly, I would say, even more on the claims descriptions and the drawings rather than the prosecution history. I mean, of course, also, again, switching the side and pretending to be a US lawyer, which I'm not. Of course, they would also focus on the claim wording and so on. But then thereafter, they will have a deep look into the history of the file, of the prosecution file. Whereas in Europe, the second step would then be to look into the description primarily and also the drawings in order to understand what actually the claims is trying to define. So I would say the file wrapper is traditionally not so much decisive in determining claim scope. This changes a bit from one division to the other. We come to this maybe later.
Okay.
But in general, the UPC division rely more on other things, specifically the description and the figures. However, there's an ongoing debate among the divisions of the Unified Patent Court about whether and in as far such doctrine might play a larger role. Certain advocates, I would call them, for applying file wrapper estoppel ideas argue it can provide additional clarity in such cases where the claims and descriptions are at least ambiguous. But others caution more or less that over-reliance on the prosecution theory could lead to inconsistencies and undermine the very predictability of the UPC which they aim to achieve.
So let me ask you just this one question. So do you see that the U.S. jurisdictions and the UPC and EPC would somewhat come together for a more generalized approach, or the U.S. will never be like the EPC or the UPC as far as how they do their judgments?
Never say never, but I mean, if I could see that they come closer.
Okay.
For example, we will have maybe later look into the decisions we have so far on that issue. I mean, there are tendencies within the UPC to adopt something similar to a file wrapper estoppel, which would be a step towards the US courts. And also, I mean, that maybe the US courts approach the European thinking a bit more.
Okay.
We have to see. I don't think that's a question where you will never find a harmonization.
Okay, gotcha. All right, good to know. So, and then let's talk about something else: UPC case law and current trends. Tilman, recent UPC decisions have touched on this topic. Could you walk us through some of these cases and what they reveal about the UPC stance on file wrapper estoppel?
Yeah, of course. I mean, let's maybe start with the Court of Appeal and what the Court of Appeal teaches us.
Okay.
The Court of Appeal clearly says we are not decided yet. Or at least they say we do not want to decide yet. They had two chances, two cases where the first instance provided some decision or delivered some decision where history of the prosecution file played a role. And in both cases, they kind of avoided it. They said more or less, well, the claim as such must be interpreted in a certain way. And we don't think that the prosecution history would change something. And because it does not change something, we do not have to decide whether it would play a role at all. So this is the one case of the Court of Appeal with the reference number Court of Appeal 1 out of 2024. So the first case in 2024, interestingly. And then there they said actually, well, we do not have to decide it yet, which is on the other hand, for me at least, a clear sign that they are not finally determined how they would decide if it would be necessary. Some rumors say, well, file wrapper estoppel might not play a big role at the Court of Appeal, but we don't have settled case law. We have, however, case law from the first instance, much clearer case law. One case from the Munich division and two cases from the Düsseldorf division. And they differ quite significantly in this regard. The Munich division said in a head note, I translate into English, that the original wording of a claim, so the claim as filed originally, the original wording of a claim in a European patent can be used as an interpretive aid in the context of amendments made to the claim wording during the grant proceedings. So what they do here, this is actually kind of a file wrapper estoppel, at least as far as I understand it. In the very least, they open the door for some further sources for their claim construction, claim interpretation. Because Article 69 of EPC says, well, the sources for interpretation are description and drawings. And here they say, well, we have a third source, the original wording of the claim. This at least opens, as said, the door for file wrapper estoppel very, very much, if it's not even a file wrapper estoppel in US style. Then we have, on the other hand, the Düsseldorf division, and they now said twice, once also in a head note, that, well, the history of the prosecution file is, in our opinion, or in their opinion, not any interpretative aid for claim construction.
Really?
So
okay.
They simply say we cannot consider it in, at least not in a file wrapper estoppel idea.
Okay.
They say, however, and this is also interesting, also for daily practice, it may play a role, what you say, in the prosecution, during prosecution. It may play a role because we understand your submissions at that time, being submissions from a technical knowledge person, and we take it very serious, what you say there. So if there's any doubt in how to understand the claim, and we see your submission at that time, then we might lean towards an interpretation which is in agreement with that submission. So if you later then, during infringement proceedings, argue for, let's say, a broader interpretation, usually you want, or always, you want to argue for a broader interpretation, then this might be a problem, because they say we have this submission and this sounds convincing. It was a submission from a skilled person, namely you. And therefore your kind of new or amended interpretation is not very convincing. One last decision, a very recent decision of the Court of Appeal again, is also of a certain interest in this regard. This was a decision where, well, in the end, it was no specific reason for the court even to discuss the file wrapper estoppel, or whether there is a file wrapper estoppel or not. However, it's from another perspective very interesting. It's the case Court of Appeal 405 out of 2024.
Okay.
And there, again, similar to what the Düsseldorf division has said, they found that certain submissions from the patentee or then applicant during prosecution showed that something has to be understood in a certain way.
Okay.
And they said, well, we take that serious, and you are an expert, more or less, as a patentee, and therefore it was very detrimental for the patentee's case. So bottom line, I mean, maybe first takeaway, anyway, whether there is a strict file wrapper estoppel doctrine or there isn't, what case law shows very clearly is that you as an applicant or later patentee should be very, very cautious what to submit, what to allege during prosecution.
So, Tilman, this brings me to one question that maybe takes it away. If you're prosecuting for your client and you're dealing with, it's almost like you're dealing with different flavors of the month with different judges or people hearing the cases, that they may allow this as admissive, or this maybe not, or they may play with this rule and go back. How do you prepare for something like that? I mean, if you're litigating this thing for your client, how would you even begin to figure out what's going to be allowed and what's going to be not allowed? You know, these kind of things. It seems so difficult to pinpoint how the judge, what will allow in Dusseldorf or Munich or whatever. And it's really hard to, it seems like hard to figure out the right tactic.
Yeah, absolutely. I mean, in the end, you need a crystal ball. You need to know during prosecution before which division you might end up in an infringement case.
Okay.
And also, this is often the problem in our job, I would say. On the one hand, you want to say as little as possible, and on the other hand, you want to say as much as possible. I mean, you want to say as much as possible to convince the examiner even to grant the patent. I mean, this is your first problem, to get the patent out of the office.
Exactly.
You need a grant of the patent. Before that, you don't even have to think about litigating it. On the other hand, you want to say as little as possible, because you have also be cautious that whatever you say will be relevant during patent litigation. And even if file wrapper estoppel doctrine is not applied, even then they can say, well, you said at the time, you said this should be interpreted like that, and this is why now different. So, and therefore, I say you need a crystal ball. Yeah, I mean, you need to think twice or three times whatever you write down. And this is
And
a
I think,
difficult task.
yeah, it sounds like it. It sounds like it. So then moving on to implications for patentees and litigants. Given this open question, Tilman, what does this mean for patentees and their attorneys? I mean, how should they approach the claim drafting and prosecution before the UPC, which is kind of like what we were talking about. But yeah, what do you think?
Yeah, we touched that. You're right. We touched it a little bit. I might add that you mentioned claim drafting.
Mm-hmm.
Usually, if you have to argue heavily how something has to be interpreted, or very often,
Right.
the claims are not so ideally drafted.
Right. Yeah.
Sometimes it's different. Sometimes it's out of the situation because you could not know something which puts doubts on any wording or something like that. But often there are minor flaws in the drafted claims, and therefore already when drafting your claims, I would always recommend to be as clear and concise as possible. This sounds very trivial, and you need this, by the way, also because the European Patent Office requires clear and concise language, Article 84 EPC.
Okay.
But on the other hand, at least in recent years, they are more generous than before, I would say. So there is a high likelihood that even if a claim is not logically 100% clear and concise, it will be granted. And I think this is good. I mean, in former days, it was, at least from my perspective, a little bit over formalistic.
Okay.
Now we have a more reasonable approach from the EPO. This is good. But also this means if you have unclarities and ambiguities in your claim, they will be granted. And then you face these troubles.
Ooh, okay.
Because then there's ambiguity, and then you need interpretation, and then maybe the other parties say, well, it's ambiguous, but you have said the following during prosecution, and therefore we do not infringe. If the claim as such is clear, I'm almost certain that any division of the UPC will not rely to a relevant degree on the prosecution history. This is my assumption.
It's kind of like a Pandora's box, it's like you open it up, but then, it can come back and bite you. Yeah.
This is a nice wording. It's exactly like that. And therefore, I mean, first advice, claim drafting is a difficult task, and it should be done with all due care and effort and time and all of that. And then you have a strong patent which you can actually litigate in a way that you, at least to a certain degree, can estimate the outcome of your proceedings. The more ambiguity you have, the more vagueness you have also regarding the outcome, of course. Yeah. You mentioned also prosecution. There you must be careful what you say. I mean, before you say, well, feature so-and-so has to be interpreted in that way, think twice whether you even need this argument.
Wow.
I very often read responses to office actions, also in litigation cases, where I think, why did they even interpret it in that way? It was clearly novel and inventive for other reasons. So there was no necessity to argue for such interpretation of any feature. So argue what you need to argue and think twice whether you even need such argument for your prosecution case.
So let me play devil's advocate. So you argue and you say only what you need to say, but if you lose the case because you didn't say enough, maybe that would have helped. It's always either or, but I'm just, what is when you say too much, what is too much? What could too much be for?
Too much is definitely something which was not relevant at the time where you submitted it.
Okay, gotcha.
Let's assume you have a prior art and you have a claim on file at a certain stage of the examination proceedings. And you have one really strong argument, which is clearly sufficient for novelty and inventive, let's say. Then avoid to bring any other argument, be it strong or weak, where you need to argue that the claim must be interpreted narrowly. So omit this additional argument. I mean, often when you are specialized maybe in prosecution, you also have kind of the
rules,
the idea that you have to bring each and every argument.
Okay.
The more, the better. But if you look in the future to future litigation cases, it's not like that. The more is not always the better.
Wow.
Even
excellent.
if it's as such a good argument for prosecution. If you have another one or two good arguments, then omit it.
Wow.
Yeah.
That's kind of interesting. I mean, it's like you always think you want to drive your case home and have the most evidence and everything that you could possibly have to make it, as we call in English, a slam dunk case, but then now it's like you have to choose your words. That balance is probably got to be the most difficult thing that I think prosecutors have to have, that Feingefühl, as they say in German, which is that fineness, that deftness, when to say too much or when not to say too much and when to say enough. That is just amazing. So with the next question I would have is, what strategic considerations should litigants keep in mind when arguing claim interpretations before the UPC? What do you think?
Let's assume the prosecution has been done, the patent has been granted. What can you do during litigation? And I have to say, not much. I mean, what are your options? You of course should kind of play with the divergent case law of the first instance. For the moment, we do not have a settled case law from the Court of Appeal.
Okay.
So, of course, your strategic considerations should imply that you refer to the Munich division if you want to argue for an appliance of file wrapper Estoppel, and you refer to the Düsseldorf division in cases where you do not want to consider the history of the file. The problem is a little bit that most of the cases are either Munich or Düsseldorf.
Okay.
So,
well, you only have two choices there. Okay. Yeah.
Well, not even, because in Düsseldorf, you will face really difficulties to convince them that they have been wrong in the past, and then they have to apply the Munich approach. Vice versa, in Munich, you will. It will be a tough time to convince them that they've been wrong in the past, and that
so let me ask you this: is there that regional conflict between states, like Munich and Düsseldorf? Would you say you can't come into Düsseldorf and give us your Munich tralala here, or in Düsseldorf we did it this way, and in Munich? Is there a little rivalry in how the?
Well, I would say there's a very healthy rivalry, and this is probably common among courts which are competent for the same subject matter. Normally, they are very close in many things.
Okay. Well, then with that, we're going to leave that until our next UPC episode. Thanks, Tilman, for your insights as always, and thanks for taking the time out. It's always a pleasure talking to you and having you on here from your busy schedule. It's clear that while the UPC is hesitant to embrace file wrapper Estoppel, its case law continues to evolve, and for now, patentees and litigants must navigate this uncertainty carefully. So to our listeners, thank you for tuning in. Join us next time as we delve into more UPC developments and their impact on patent litigation. Tilman, thank you once again for joining us. For our listeners, you can check out all of our past shows as well by joining us on YouTube, Spotify, or going to our website, www.meisterbolter, or that's www.meisterbolter.de or .com. And once again, Tilman Pfrang, thank you for your expertise. Always a pleasure to have you on the show. Tilman, you know the routine. Auf Wiedersehen.
Auf Wiedersehen.
Ciao.
Ciao.